You signed an NDA when you joined, but do you actually know what it can and cannot make you do? Today I'm sitting down with Benjamin Maltby, a maritime lawyer at Keystone Law, who specializes in superyacht law and represents owners, managers, and senior crew. And the answers across the board are more straightforward than the industry would have you believe. We cover what an NDA is actually designed to protect and what it legally cannot touch. We get into criminal conduct, harassment, drug use on board, and the moment hush money crosses into criminal conspiracy. We talk about what happens when a crew member dies and whether those left behind are legally required to keep working. Let's dive into the interview. Hello, everyone. Welcome to Yachting International Radio. You're with Karine Rayson from The Crew Coach. And today I have Benjamin Maltby from Keystone Law. And we are very lucky to have him. I watched your interview recently, Benjamin, at the Superyacht Investor Forum. And I love your human approach to your questions.
Thanks. Hi. Well, it's great to be with you. And yeah, thanks very much. I'm looking forward to your questions.
I know that
I should just say at the outset, I'm an English lawyer and I can only talk in respect of English law. Mm-hmm. That said, English law applies broadly, in broad terms, in Commonwealth countries and to a lesser extent in the United States. So it does not constitute legal advice, but I suppose it could be treated as guidelines.
Fantastic. Thank you for clarifying. So I think the subject of law is quite a scary subject for crew, personally.
Yeah.
And I also believe with the NDAs that we have in place and the sheer wealth that these owners have, that if there is an issue, I think they're quite tentative in terms of approaching it. So they just let it go. But anyway, I'm sure it will come up in conversation. I'll start with my first question. In simple terms, what is a NDA and what is it genuinely designed to protect in a superyacht environment? I understand it's more to protect the owners.
Yes. Okay. Well, an NDA can take one of two forms. It can be a standalone agreement or it can form part of your employment agreement. That it doesn't really affect the validity of an NDA either way. Mm-hmm. The thing is about NDAs, I mean, crew shouldn't be scared of NDAs or any legal matters generally. I mean, the law is there to manage relationships, to oil the wheels of how we all interact and how we behave towards each other. It's nothing to be scared of. Mm-hmm. It is what it is. I mean, NDAs, in essence, are there to protect owner privacy. They're there to protect commercial information, such as charter rates and so on, and also anything related to security, such as itineraries. And from an owner's perspective, that's fair enough.
Then what are the consequences if a crew member breaches an NDA? For example, let's say it's stipulated that there should be no photos taken of the vessel or parts of the vessel, and a crew member posts themselves in the guest cabin.
Yeah,
that goes on Instagram. What are the consequences?
It happens. So, in their employment agreement, there will be a disciplinary procedure. Mm-hmm. So, it's not necessarily the case that they will be sacked immediately and taken to the cleaners. The disciplinary procedure must be followed, and consequences can flow from not following that disciplinary procedure. That said, a breach like that of an NDA could constitute gross misconduct and could be grounds for immediate dismissal. It would have to be shown that the owner's privacy had been breached. Mm-hmm. And to take that example, I mean, there may be other rules, such as crew are only allowed in the guest cabins for cleaning and maintenance, not for messing around or taking selfies. But that's probably not a reason to sack someone. So, I mean, other than that, is the owner's privacy really being compromised by that? I would suggest not. It's an irritation. It's a bit cheeky. It goes against the rules. Mm-hmm. Is there any... I mean, it's a question of fact. rather than a question of law in each case as to whether or not the owner's privacy had been breached, but are there personal effects being photographed? It's a personal space, but I think to take that example, the owner would have an uphill task in proving that his or her privacy had really been breached. If you could see out the window that they were in Monaco, and were obviously in Monaco, you could see by landmarks, that would change matters quite dramatically, because that would show that the yacht, and also I should mention, has the crew member named the yacht? If they haven't, they're just in a random just in a random guest cabin, could be any yacht. But if he or she says, yes, I'm on this boat and I'm in Monaco, and it's obvious by looking out the window, then you could well say that they breached their privacy and indeed compromised their security. And that could be grounds for dismissal, as long as the disciplinary procedure has been followed.
Fair enough. And why are we seeing more extensive NDAs in the industry at the moment? And how have they developed over time, do you think?
How have they developed
over time? Like if you compare years ago to now?
There was a time, only about, 20, 25 years ago, when famous people were normally film stars, pop stars, and they may or may not have had enough money to buy a super yacht. Wealthy industrialists were not well known. And times have changed, and we now know who those wealthy industrialists are. They are famous because of their wealth. People know what they look like, what their partners look like. And also now, of course, we have social media. So if you combine those two factors, why do owners buy yachts? They want them, obviously they enjoy yachting, but also they want privacy and they want security. Those are primary drivers behind a super yacht ownership. So the last thing you want is for their identity and their location and details of their private lives being shared on social media just because a crew member is doing it for the gram.
And also in this day and age, we've got drones and
We have drones, yes. We also have a greater sense of reputational risk as well. Also, owners just don't want, pictures of their kids. You and I are both parents, and certainly the two schools that my kids go to have very strict rules about posting pictures taken at school or of kids other than your own, taking them generally, and certainly not posting them on social media.
Fair enough.
And it's the same thing with owners' kids and families. They don't want those details in the public domain, thanks so much.
Great. One of my favorite.
It's the same with politicians. It's the same with film stars. They'll be very strict with the media, and they will sue to protect the privacy of their loved ones, which is fair enough.
So, this is one of my favorite questions. Can an NDA legally prevent a crew member from reporting criminal conduct, harassment or assault, unsafe working conditions, environmental breaches? Because I know.
Okay, I'll deal with all four of those, and the answers are no and no. So criminal conduct, no NDA can override. No NDA can prevent the reporting of any criminal conduct. Full stop, for obvious policy reasons.
Yeah. Yep. So a long time ago, there was a vessel that was bringing on underaged sex workers, so under the age of 18, and that would constitute as criminal conduct.
Absolutely, yeah.
How would a crew member report that?
They would, so presumably if that child, and we are talking about children, if that child was taken on board within port state waters, then you would report it immediately to the port state police. You would also always report it to the flag state authority as well, because the flag state law always applies, and the port state law applies when you're within territorial waters, which is normally within 12 nautical miles of the coast. So you would do both those things immediately, and you would preferably take photographic evidence to obviously by way of doing the right thing, and also to support your own position as well.
Okay. Drug use is prevalent on yachts?
Yep.
Whether it's
exactly the same thing applies.
Really?
Yep.
Oh my goodness.
Yeah. Oddly enough, the consumption of cocaine is illegal in every country that I can think of. Certainly every flag state and every port state law I can think of. It's a serious criminal offence.
And you can be detained, or the boat can be detained.
And the boat can be detained, the owner can be detained, the crew can be detained. Yes, it's a serious criminal offence. So, I mean, it's certainly putting on the back burner, should or should that not be reported, that's an entirely separate issue. But it's certainly in terms of can an NDA prevent you from reporting that behaviour? Absolutely not.
Okay, I'm just going to sidetrack here. Unfair dismissal, for being dismissed for no plausible reason.
Mm-hmm.
She mentioned
that's unfair dismissal. So if the owner, or more likely the manager, decided that the NDA had been breached because a crew member had reported criminal activity, even if that crew member was mistaken, the crew member would be able to make, certainly in England, a claim for unfair dismissal. Mm-hmm. That would be they would take that claim to an employment tribunal,
yes,
which would be public.
Yeah.
Now, normally, if you have, say, a management agreement or a superyacht sale and purchase agreement, you will agree to arbitration, which is like a private court. And you take your case, you present it in a very similar way to how you would if it was a public civil court. And in fact, the arbitrators can sometimes be themselves judges, working as arbitrators part-time, or they could be retired judges. And you receive an arbitration award, but the arbitration process itself is entirely private. Mm-hmm. It doesn't normally, it can under certain circumstances, but it's normally an entirely private matter. And the reason that the parties choose arbitration is to keep it private. As soon as a disgruntled employee brings a claim to an employment tribunal, that is the case is very much in the public domain.
Okay. While you were sharing, I was thinking about threats. Like if there is an owner who's affiliated with a gang, had that experience before through a client, and they threaten to kill their family if they disclose anything. What do you do?
What do you do? Well, first of all, I mean, as soon as you understand that is the sort of person you're dealing with in terms of a beneficial owner, you walk away. Because that is someone who deems themselves to be outside. That, some people just do. Hardened criminals perceive themselves as working outside the law. They don't stick by the rules that govern civil society. So, do you want to work in that world? No, of course you don't.
You better
walk away at the first opportunity and don't look back.
Yeah.
Why on earth would you want to involve yourself in that at all?
Yeah, fair enough. Okay.
Yeah, it's a non-starter. And the idea of, an NDA being enforceable or not, these are people who don't, just don't play by the same rules as the rest of society. So we just walk away at the first opportunity.
Okay. And I think we've answered the question around what protection is available around disclosures, because if it's a legitimate report, then you can breach or break that contract, that NDA.
Yes, even if you're mistaken, because that case won't have been decided. I mean, you can't report. You're only ever reporting a suspicion of criminal activity. The criminal activity, as far as the law is concerned, hasn't happened until there's been a conviction.
Yes.
You're not waiting for that conviction. You're reporting a suspicion, and you're allowed to report a suspicion. So nothing has to be proved. You have to have a reasonable belief. It's normally pretty obvious.
Should crew take out any protection, whether it's a lawyer or being part of a union? They are waiting for the law to decide.
Well, I mean, certainly as far as English law is concerned, an owner wouldn't have a case against them. So while an owner may sort of huff and puff and threaten legal action, as soon as the owner takes advice, as long as that advice is correct, which is quite a big if, I suppose, but as long as that advice is correct, there's no lawyer in their right mind who would advise them to pursue a case against a crew member under the circumstances.
And would a crew member, what would that look like for a crew member if it's proven to be a crime?
It wouldn't look like anything. I mean, the crew member would be quite within their rights to have reported the offence. The employment continues, theoretically. The crew member may almost certainly would feel very uncomfortable with the whole situation.
Yes.
And would want to leave the vessel. So then you would look at the notice periods, and they would still have to be complied with. You would have to submit your notice and, if necessary, work through your notice.
Mm-hmm. Fair enough. And when there is the statement of lifetime confidentiality, so once you've completed employment, does that term hold even though you're not employed or have a contract?
For all intents and purposes, no, because it can never apply if what you are reporting is a breach of the law. So it wouldn't apply from day one anyway. And courts would almost certainly see some sort of lifetime gagging as excessive. Because as I said at the outset, the only reason you would have an NDA agreement or an NDA, a non-disclosure clause, is to protect legitimate commercial interests. And over time, those commercial interests fade. I mean, who cares what charter rates were charged 10 years ago? Doesn't matter.
Yeah, true.
Who cares who an owner was 10 years ago? Doesn't matter. So why would the owner want to enforce those elements of the NDA or the clause? They're not going to. And even if they did, well, so what? The thing to understand about all this is you're only talking about an action being potentially brought against a crew member in the civil courts, not the criminal courts. And all that the civil courts can do essentially are one of two things. One is to grant an injunction preventing someone revealing information, which is unlikely. But the main remedy in the civil courts is damages, the payment of money. So then you've got to quantify the loss suffered by the owner. Well, how do you do that? That's very tricky, first of all, and therefore expensive to argue. And secondly, if you're dealing with, say, a 23-year-old deckhand, they are what, if it's a man or a woman, doesn't matter, they are what the law calls a man of straw. In other words, they're very unlikely to own property. They're very unlikely to have significant amounts in savings, even if you knew where those savings were held. And you're throwing good money after bad if you go after someone who you aren't absolutely certain has some sort of property or savings or, some sort of net worth that you can, preferably freeze or, somehow locate before you bring an action. And that's very unlikely for a young crew member. And so the whole rationale for bringing an action just falls away. You might have an owner who carries on just out of spite. The other thing to bear in mind is unless there's an arbitration, as I said earlier, and employment agreements very rarely, if ever, have arbitration agreements. I'm not sure it'd even be lawful to have an arbitration agreement within the employment agreement. So the beneficial owner would be bringing a case in the public courts. Mm-hmm. And the judge will want to know who the beneficial owner is and how their privacy has been compromised or violated. And the media absolutely loves a super yacht story.
Yes.
They'll get to hear of it, they'll get wind of it, and they will swoop and devour every detail of it. And that's not really what the owner wants, because after all, if you want privacy, the last thing you want to do is to bring an action in a public court.
Fair. Hush money happens a lot in our industry. Is that legal? Illegal, I mean?
They could pay you, well, it depends what is being hushed. Mm-hmm. I mean, if you had a valid NDA or a non-disclosure clause in your employment agreement, part of what you're being paid in terms of salary, in a sense, is hush money, isn't it? Because part of your employment is that you maintain confidentiality, in return for which, as well as obviously doing your work, you're being paid your salary. So, but I get what you mean. I mean, if something occurred and you were asked to be paid hush money, it depends what was being hushed up.
Something illegal. Yeah.
Something illegal. Then you would have an agreement to somehow look the other way. Could you be seen as part of a criminal conspiracy?
So let's say you receive hush money, you sign some sort of legal document to say that no information will be leaked out, and then somehow there's an investigation, like the Epstein case, and then you are interrogated, and then you become part of that crime. Really?
Yes. Yes. Well, I've just said at the outset, I'm not a criminal lawyer. Obviously, I have an understanding of criminal law. But I mean, to take the Epstein as a very good example, say if you were paid to look the other way while Epstein took children on board his yacht. And it was fairly clear that, that there were no other responsible adults. Clearly, he wasn't a responsible adult. There was something clearly untoward going on. You would almost certainly be a conspirator to that offence. And under English law, you would be just as liable as the main perpetrator. So, I mean, going back to disclosure, there's absolutely no way that receiving money would be lawful, and there's no way that I mean, you just wouldn't go there. I mean, why would you? Clearly, something horrendous is going on. It's your duty as a human being, never mind as a law-abiding citizen, to report that and put a stop to it immediately. Why wouldn't you?
But then it becomes complicated if you are, let's say, 22 years old and you've been told to take the hush money or else you might...
You grow a spine, you don't take the money, you walk away, and you do what you can to make sure it doesn't happen to other people. Because one day you might have kids.
You call on professionals for support and guidance. Yeah.
Absolutely. Yes. Yeah.
Okay. If a yacht flies a Cayman flag and operates in the Med and the crew member lives in the UK, which law applies?
Potentially all of the above. The flag state law always applies because the yacht doesn't stop being registered in a certain flag state. The port state law applies within 12 nautical miles of the shoreline. UK law can be made to apply under certain circumstances. This is an area of law, of English law, that is developing. There was a case recently of a superyacht crew member who spent some of her time in the UK. She was working on rotation and she had a bank account in the UK. That was enough for a connection to be made to the UK and for the case to be brought before the British Employment Tribunal. So potentially all three.
So let's say there's a British crew member who has conducted physical assault, then you would report it to port state authorities in the Med, the flag state, let's say it's Cayman Island flag.
Yes.
And then in terms of, I guess it's about the victim. If the victim's from the UK, then who do they see in the UK?
So English law would apply only as it affected the employment agreement, or well, actually more broadly, your employment.
Okay.
So in terms of the crime that's been committed, that is the concern of the port state law and flag state law. Primarily because they're there on the ground, port state law. Because they have, boots on the ground, they can go and do something, they can take evidence, they can take statements, and they can prosecute. How the flag states law would, whether or not they want to prosecute as well, or probably not, because it's, if you say it happened in, France, the French police would deal with it, and the flag state law probably say, well, it's been dealt with by the port state law, there's no reason for it to be tried twice. But both of those issues are separate to the employment law matters, which should be dealt with by the Employment Tribunal.
Okay. And port state authorities are effectively the police in the local port.
They are literally the police, yes, the port police, yes.
Yes, yes. Okay. Trying to see if I've got another question there for you so I don't repeat myself. From your perspective, where is the line between protecting privacy and covering up wrongdoing? I think we've certainly cleared that up.
Yeah.
Okay, this is a good one. What responsibilities do captains and management companies have to ensure NDAs are not misused?
The management company managers owe a duty of care, generally, and under the management agreement to the owner. If something is being covered up, the owner will want to know. And the owner will want to know, well, the owner will want to know because he or she will want to know that his or her yacht is being managed effectively, and he and his family and the crew they normally care for at an emotional level. You know, they don't want anything, they don't want them exposed to any unnecessary risks. So if there have been any, for example, regulatory breaches, they want to know. They also want to know because the insurance company wants to know, underwriters want to know. Because if there's been a serious regulatory breach and it results in an accident, potentially the yacht could sink and the hull, i.e. the first party underwriter, could if they knew about the regulatory breach, could then, or the regulatory breach became evident after the accident, they could say, no, we're not paying. Because one of the conditions was that the vessel remained, for example, in class, and it's not in class because there's regulatory breach, or there's just a regulatory breach generally, and that has resulted in an accident, and we're not going to pay.
Yeah.
So from that perspective, the owner wants to ensure that physical risks are being managed and also financial risks are being managed. Mm-hmm. So if there's been a regulatory breach, then they are going to want to know. Against that, though, the regulatory breach might be because there's been a screw up by the manager or the captain, and they might not want the owner to know. So, but yeah, from an owner's perspective, they want to know, definitely.
Okay. I'm going to steer away. I know that we haven't discussed this, but if I can steer away a little bit from NDAs and share some life examples, situations that is out there in the media anyway. If a captain is intoxicated and there's an accident and crew are injured, what is their legal stance for the injured crew member?
So, tricky on that, because the injured crew member will look for financial compensation to the yacht's third-party underwriter. The third-party underwriter may say that the yacht itself was unseaworthy because no one was in effective command, because they can't have been because they were intoxicated. I mean, there are evidential issues that arise immediately, because how do you prove after the event that they may have had a drink? Were they drunk? We don't know. If the port state police turned up and immediately breathalyzed the relevant crew member and found that, yes, they were, 10 times over the legal, whatever the local legal limit is, or had any alcohol in their blood at all, there might be an absolute prohibition on any sort of drinking at all. Zero tolerance policy. So if that was the case, you might have a fight on your hands with regards to the third-party underwriter. The crew member, of course, still has an action against the owner, and the owner still owns the yacht, so the owner is still worth something. It'd be a problem if the yacht was about to be sold. Then again, you may have a claim against, if you had a claim against the vessel itself, that might survive a sale. So that would be the new owner's problem. When you're advising buyers, you always get the crew to sign something to say that they have no outstanding claims against the owner or the vessel. And you're going to want to make sure that crew member has been properly compensated. Otherwise, they're not going to sign that document, and it's going to raise flags with the buyer.
Mm-hmm. Mm-hmm. Okay. I know I've discussed this privately with you in relation to a crew member that has been overworked and experiences severe health issues as a result. They get put on medical leave.
Yeah.
And then for no reason, let's say they get let go.
Yeah.
Where does the crew member stand then? And
well, you can't be unfit to work indefinitely, if you see what I mean. So it may sound harsh, but if for example, I don't know, you break an arm and it leads to a permanent disability and you're unable to do your job, then you can look to the owner for compensation, but that compensation has a limit. And that assumes, of course, that the owner was at fault. You may have just been careless yourself and caused the accident yourself, in which case it's on your own head. The owner's not there to just make sure everything's right in the world. You have to take responsibility for yourself. If you were handed a piece of equipment and you're asked to use it, and unbeknownst to you, that item of equipment was faulty and it led to an injury, then yes, you can have a claim.
Okay. I also know in the media not so long ago, there was a crew member, and this is quite common, fell down the stairs and passed away, like broke her neck or something to that effect. Then who's liable? I guess it also depends the crew member's intoxicated.
Yeah, I mean, I can't really give an answer to that because there'd be so many evidential issues at play. Had they had a drink? Were they completely incapacitated? I mean, obviously, in a situation like that, in my experience, third-party insurers tend to be mutuals. They tend not to be commercial insurance companies, and they tend to be very patient and not necessarily generous, but they look kindly upon crew members. And they are, in my experience, extremely helpful. And they do what they can. But I mean, to answer your question, that really depends on flag and port state law. Okay.
Sexual harassment is very common in the industry. And hearing you speak, if I was going back into the industry as crew, I would want some sort of protection for myself. Is there such a thing that you could get in case you experience, let's say, worst case scenario, rape from a guest on board?
Well, obviously that, a serious crime will have been committed. Yeah. Time will be of the essence for obvious reasons. You'll want to report it as soon as possible. Yeah, I mean, you will want to go to the nearest capitanery or, port states, port police, and report it immediately.
Okay, last question. I'm so sorry.
Sorry?
There is a death on board.
Yeah.
A crew member has passed, traumatic for the crew, and in our industry, we have this philosophy of the show must go on. The guests are arriving in 2 days. They want the vessel in Greece. We are in some other location. Are the crew obliged to work? I don't know if you know the answer of this question, if it relates to the work that you do, but...
Well, broadly, I can tell you under English law, no, you are obliged to go on.
You're obliged to go on?
Yes.
Gosh.
Yeah. There are certain circumstances. I mean, there is such a thing as bereavement leave. I think I'm right in saying, I don't know immediately, I'd have to research the point. I think I'm right in saying that bereavement leave doesn't apply in terms of co-workers. When in my 20s, I knew two people who essentially fell down dead. They had pre-existing conditions. No third parties were involved. They weren't taking drugs or alcohol, far from it. And they fell down dead. And conceivably that can happen. It must have happened at some point with crew members. But no, there is no such thing as compassionate or bereavement leave, as far as I'm aware, for co-workers. That sounds harsh.
Yeah,
it happens on, I suppose, people do die on cruise ships, for example.
Yeah.
And then you get elderly people on cruise ships. It happens. It probably happens on not every trip, but it will happen on a lot of trips. And there are procedures in place. It's all very sad, but the show must go on.
I know it does, but I mean, I first have heard some horrific deaths on board.
Yeah.
I just psychologically, especially with the nature of the work that you have to do, you're on service, you've guest facing, you've got to be on the ball, you're physically exhausted, long hours, and to process that while putting on a show is extremely difficult.
It may be that it's so traumatic for you that you physically can't work.
Yeah, okay.
In which case, you would... You could make an argument that it's the same as being physically injured, such that you can't work. But as I think the starting point is no. If you're physically capable of working, as traumatic as that may be, you would have to carry on.
Okay. Any last words in terms of what you want to impart to the industry when it comes to law? Very broad question, but there might be something on your mind that you would like crew or yacht owners to know.
I have a lot of crew members who get in touch with me and want advice on various issues. And I wish they didn't, because I wish they were a member of Nautilus, for example. And 9 times out of 10, they get in contact and they're not members and they wish they had been. And they soon realize that legal advice it's not cheap. It's probably something they can't readily afford, especially if they're in a junior position. And the sensible thing would have been to have joined Nautilus and been able to tap them for advice.
Thanks, Benjamin. You've got your email address there, but those who are listening, how can people get in touch, and what is your area of speciality? And I am under the assumption there, based on what you've shared, that your clients are primarily yacht owners.
Yes, so my practice is split 50-50 between owners on the one side and suppliers on the other. I do deal a lot with project managers and captains and yacht managers and various other equipment and service suppliers. So from that perspective, I do deal with crew. They tend to be more senior crew.
Okay.
And their employment agreement will often be quite bespoke.
Understood. Benjamin, thank you kindly for your time. It's very generous of you. And
no problem at all.
Looking forward to staying in touch. Thank you for what you do.
If your brand belongs in the heart of the yachting world, this is where it happens. Yachting International Radio reaches over 1 million yachting professionals and enthusiasts every month, with 77 million impressions, 220,000 social followers, and 74,000 podcast subscribers. Our hosts are insiders, crew, captains, CEOs, trusted voices shaping the industry. This is targeted, high-impact advertising in a luxury niche. Visit yachtinginternationalradio.com/advertise. Your audience is already listening.